World Wide Web. I'm Faris Al-Rawi, the Minister of Rural Development and Local Government. I am appearing before the media this morning in my capacity as a member of the government and to speak in relation to matters that occupied my attention whilst I served as the Attorney General and Minister of Legal Affairs of the Republic of Trinidad and Tobago in the period September 9th, 2015 to March 16th, 2022, nearly 7 years. Specifically, I have paid attention to the statements coming from the leader of the opposition, Mrs. Kamla Persad-Bissessar, had a press conference yesterday. And in that press conference, she specifically observed and made a lot of statements coming in relation to the matter commonly referred to as the legal kickback fees matter. That is a matter in which Anand Ramlogan and Gerald Ramdeen were both charged by the Director of Public Prosecutions to answer matters of criminal nature in relation to statements revealed by a gentleman by the name of Vincent Nelson, now King's Counsel. Mrs. Persad-Bissessar made a number of observations yesterday, which I am compelled to put into context and to answer. Now, permit me to start off by indicating that the Director of Public Prosecutions, who has a constitutional role under Section 90 of the Constitution to institute charges, take over charges, and also to drop charges, acting in his sole discretion, took the step to charge Mr. Ramlogan and Mr. Ramdeen after he had received evidence coming from Mr. Vincent Nelson and a number of other persons. Mr. Gaspard, in his own discretion, unfettered, also took this step on the 10th of October, that is this Monday, to drop the charges against Mr. Ramlogan and Ramdeen, but the Director of Public Prosecutions specifically said two things that are of important note. Mr. Gaspard pointed out that his office considered applying to have Mr. Nelson's witness statements tendered into evidence without him having to testify and being cross-examined over the contents, but decided against it at that point. And specifically, Mr. Gaspard was careful to note that his office may decide to reinstate the charges after Nelson's lawsuit is eventually determined. I've made those observations because in speaking to the media today and in answering Mrs. Persad-Bissessar's wild and unfounded and untrue accusations, I'm compelled to point out that I am bound to be very careful in what I say because the Director of Public Prosecutions has to have the independent right to consider a matter, being careful that as a witness in proceedings that I do not overspeak the matter. The Privy Council has been very clear in its position to warn that trials ought to be fair. And in doing that, in a very famous case in Trinidad and Tobago, Nankisoon Budram, that's the Dole Chedi case, the Privy Council also gives certain guidance as to cooling off period. The cooling off period means that a fair trial must be ensured and that the population needs to be given enough chance for a matter which has been the subject of a lot of conversation or undue publicity. The population must be given a chance for that to be cooled off and time is given before a trial is commenced. Therefore, ladies and gentlemen, I would like to state very plainly that Mrs. Persad-Bissessar's attempt is one to bait the government, and in particular me, to overspeak on a matter, to fall into a trap of undue publicity where attorneys can argue that their clients will not have a fair trial because there's too much information in the public domain. Therefore, I need to be careful in my regard for the law, to allow the DPP his distance, and to be mindful as a former Attorney General and Minister of Legal Affairs in this country that the law always speaks and that the Privy Council decision must be observed. So I will be very careful not to fall into a trap laid by Mrs. Persad-Bissessar to overspeak the matter. Now, let's get very plainly to the allegations that Mrs. Persad-Bissessar has put forward. The population is well aware since 2015 that the government has been concerned about expenditure under the People's Partnership Government, and in specific context, with over $1.2 billion in legal expenditure for legal briefs and other matters under Mr. Ramlogan and the government, the then government's hand, Mrs. Persad-Bissessar's government, that some $636 million alone was spent by the Attorney General's office under Anand Ramlogan as Attorney General. That's the amount of money that was spent together with the amount of money that was left over that had to be paid. Arising out of that and being careful to state the matters that are in the public domain, I can tell you that Mr. Vincent Nelson, then Queen's Counsel, gave a notarized statement. That is on the 26th of October 2017 is the date of that notarized statement. And in that notarized statement, he gave particulars of conspiracy to defraud the public. Mr. Nelson's notarized statement specifically said that Mr. Ramlogan and Mr. Ramdeen were the beneficiaries of corruption, that he paid bribes to Mr. Ramlogan via Mr. Ramdeen in a fictitious arrangement. He gave full particulars, he provided the evidence, he provided the bank statements, he provided the wire transfer information. Immediately upon receiving that information, I retained lawyers on behalf of the state. That team was headed by Mr. Douglas Mendez, Senior Counsel, and Mr. Gilbert Peterson, Senior Counsel. And as a result of that, the advice given to the Office of the Attorney General was that there's an obligation to bring wrongdoing of this nature to the attention of the authorities. Senior Counsel Mr. Mendez specifically settled a written indemnity agreement that he advised that the state enter into, and under that written indemnity agreement, the specific context was that the notarized statement and the evidence of wrongdoing will be given to the Director of Public Prosecutions and to the Anti-Corruption Investigation Bureau. In that indemnity statement as well, the state undertook on the advice of Senior Counsel that no civil proceedings would be commenced for the recovery of legal fees that were paid to Mr. Nelson, and also that there would be a certain amount of indemnity if there was a breach of the indemnity in giving that statement to persons who ought not to have that statement. That was specifically subject to the Attorney General's obligations in law and under statute. So it was a very qualified, careful indemnity settled by Mr. Mendez, Senior Counsel. After that, I can tell you that Mr. Nelson then participated on at least 10 occasions in confirming his guilt in the matter and in confirming his position in relation to the fact, as he alleges, that Mr. Ramlogan and Mr. Ramdeen were guilty of bribery and other matters in stealing taxpayers' money by way of kickback of legal fees. Specifically, Mr. Nelson gave written statements to the Trinidad and Tobago Police Service. He did so in 2019, January, in February 2019, in May 2019. Mr. Nelson then entered into a plea discussion with the Director of Public Prosecutions. I want to remind that under the laws of Trinidad and Tobago, there's a specific piece of law. It's Act number 12 of 2017. It is called the plea bargaining legislation, putting it in simple terms. It is an act assented to on the 27th of September 2017. In that particular act, the act was to establish a system of plea discussion and plea agreements and for matters incidental thereto. Mr. Nelson, under that law, proceeded to engage in a direct discussion with the Office of the Director of Public Prosecutions via his attorneys at law. The Office of the Attorney General had no part or parcel of that, save that I, as Attorney General, carried out my obligations and provided the DPP with the material that was provided to the state, which is the notarized statement as well as the indemnity settled by senior counsel. The plea discussion occurred in the period February 2019 to May 2019. In that, the Office of the DPP and Mr. Nelson and his attorneys, they participated in a discussion. They then entered into a plea agreement under the legislation. That is the Office of the DPP and Mr. Nelson. And that was entered before a magistrate on the 2nd of May 2019. That plea agreement, again, involved no participation of the Office of the Attorney General. As you know, under the Constitution, the Office of the Attorney General deals only with civil matters, not with criminal matters. That plea agreement is a matter which the DPP settled, and that was entered before the Magistrates' Court. The next step under the law is that you have to refer the plea agreement before a judge of the High Court. And I can tell you that that matter of the plea agreement and whether the court would accept it was sent to Mr. Justice Malcolm Holdip, and in the period June 2019 to December 2019, that judge had appearances involving Mr. Nelson and the Director of Public Prosecutions, and that plea agreement was entered into. Mr. Nelson, of course, pled guilty to the crimes that he negotiated that he should plead guilty to with the Office of the DPP, to the exclusion of the Office of the Attorney General. Mr. Nelson was sentenced before Mr. Justice Malcolm Holdip on March 2nd, 2020. After that, it is now a matter of public knowledge, and certainly a matter that has been inside of the DPP's office, that the DPP had to obtain witness statements from several persons. I can confirm that I provided 4 witness statements to the Office of the Director of Public Prosecutions, comprising hundreds of pages. And those 4 witness statements gave full disclosure of every bit of correspondence, all documents, correspondence passing between attorneys at law for the Office of the Attorney General, the Attorney General's correspondence as well with local and international agencies, and very specifically, all of the correspondence with the Office of the Director of Public Prosecutions. There is an obligation in law of full disclosure in criminal proceedings, and you must disclose a case which is detrimental to you. In other words, then, you can't hide anything. All of those hundreds of pages of documents were disclosed to the Office of the Director of Public Prosecutions. The DPP, of course, exercises full control over that matter, and the matter was docketed before the Chief Magistrate, and they were making arrangements for the preliminary inquiry to be proceeded with. The disclosure to the Office of the Attorney, from the Office of the Attorney General to the Director of Public Prosecutions, and specifically to Mr. Ramlogan and Mr. Ramdeen in writing, also included disclosing civil proceedings brought by Mr. Nelson against the state, where he alleged that there was a breach of the indemnity which senior counsel settled. That matter is listed before the High Court. That matter has been sealed at the request of Mr. Nelson because of pre-trial publicity, again with the caution of pre-trial publicity affecting criminal proceedings, which are either in existence or which are contemplated. And I remind you where I started off by pointing out that the media has covered the Director of Public Prosecutions, indicating that he's considering the matter of relaying the charges if he considers it appropriate at some point in the future. In treating with that particular matter, I can tell you that of the 10 occasions that I have listed, Mr. Nelson has never changed his evidence. He has never changed his evidence. He has confirmed his guilt on at least 10 occasions across the period 2017 right up to 2022. I can tell you that the state's position in relation to the civil claim is that you can claim what you want A claim is not an actuality. Contrary to Mrs. Persad-Bissessar's wild allegations that the state has paid Mr. Nelson's fine, if it is that she has said it that way, it may have been reported differently, I can tell you that that is not true. And I can tell you that the civil proceedings, there is a robust defense, and that is being prosecuted. And the Attorney General, Mr. Reginald Armour, Senior Counsel, will indeed continue in the conduct of that matter, together with whatever other steps the Attorney General may advise are appropriate in the circumstances, including further litigation if necessary, both locally and abroad. I cannot and will not speak to those matters. That is a matter for the Office of the Attorney General. Mrs. Persad-Bissessar has made a few wild allegations. First of all, that in the discharge of my responsibilities as Attorney General, whilst I held the office, that I interfered with the office of the the Director of Public Prosecutions. That is not the case, and that is to be borne out by the actual evidence in the matters. Secondly, Mrs. Persad-Bissessar has taken to cherry-picking bits and pieces of correspondence. I remind that there are hundreds of pages of witness statements from my hand alone, 4 of them, and that Mrs. Persad-Bissessar's attempt to drop a piece here and a piece there out of context must be looked at with great suspicion, reminding you that the intention, as I see it, is to ask the state to fall into a trap of over-speaking the matter and causing pre-trial publicity, which is why I am today confining myself to matters which are in the public domain solely. Mrs. Persad-Bissessar has alleged that the DPP did not have disclosure. That is clearly not the case, because all of the documents were passed to the DPP in the form of witness statements and prior to witness statements being dealt with. The leader of the opposition has alleged that there is a bias of police investigation. That is a matter for the Trinidad and Tobago Police. I want to remind that the government transferred the Anti-Corruption Investigation Bureau back to the Trinidad and Tobago Police and removed the involvement of the Attorney General's office. That cabinet note which created the ACIB in the Office of the Attorney General was a very careful one. It never allowed the Attorney General to interfere in matters, but out of caution, the Prime Minister and the cabinet returned the ACIB back to the police. The leader of the opposition has made an incredible statement saying that there were shocking revelations by the DPP about the conduct of Faris Al-Rawi. That's me. I hate it when people refer to themselves in the third person, but I'm reading what she said. I can see absolutely no statement that I'm aware of where the DPP has made any condemnation of me personally or of the Office of the Attorney General. I have seen none of that, and that is to be flatly rejected. I can tell you, in relation to Mrs. Persad-Bissessar's allegation that there's some secret indemnity agreement, that could not be the case because those matters were completely disclosed. And I want to remind you that at every step of the way in the discharge of my responsibilities, then as Attorney General and Minister of Legal Affairs, I had the benefit of senior counsel advice, which I carefully followed and carried out to the letter. The people of Trinidad and Tobago were faced with a position where a witness came and confessed to criminal conduct which involved Mr. Ramlogan and Mr. Ramdeen, and therefore there's a public duty on the Office of the Attorney General to have acted in those circumstances. The Director of Public Prosecutions is an independent office created under the Constitution. The DPP's function in treating with the plea bargain and the plea agreement and all other matters, including the discontinuance temporarily of the Ramlogan-Ramdeen matters, that is entirely a matter for the Office of the DPP. I have the greatest regard for the Director of Public Prosecutions and have absolutely no comment to make in relation to the office holder or the exercise of the office as it has unfolded. I'd like to tell you in relation to Mrs. Persad-Bissessar's allegation that there's a secret sweetheart deal. I can tell you that there's no such thing. Any civil claim that is unfolding is one that is merely a claim, I can say very simply that the state's position is that that claim is bound to fail. And that is the advice coming from Mr. Mendez and Mr. Peterson, both eminent silk in this country, who are in charge of that litigation. That is now safely in the hands of Mr. Armour, Senior Counsel, who is the Attorney General and Minister of Legal Affairs of the Republic of Trinidad and Tobago. Mrs. Persad-Bissessar made some comments in relation to Roger Kewal Singh and alleged and then called for investigations into my relationship with Mr. Kewal Singh. I'd like to tell you she referred to Mr. Kewal Singh's purchase of a vehicle from me back in 2016. I want to remind that the Trinidad and Tobago Police Service on June 15, 2022 wrote to me and no doubt wrote to Mrs. Persad-Bissessar, and this is what the TTPS had to say. It said, I refer to a letter dated 1st October 2021 from the Leader of the Opposition, Mrs. Kamla Persad-Bissessar, on the subject, which is an investigation into the failure of Faris Al-Rawi to transfer motor vehicle registration PCY 84 to Mr. Roger Kewal Singh, and the failure to notify the Transport Commissioner of a change of ownership contrary to Section 19 of the Motor Vehicle and Road Traffic Act. The Commissioner of Police said in his written correspondence, the file, he says, on the subject, and informed that a comprehensive investigation was conducted into the allegations made therein. The file was submitted to the Director of Public Prosecutions for his perusal. However, there was insufficient evidence to substantiate the allegations made therein. As such, I have decided to close this matter pending any further developments. And that is a letter from the Trinidad and Tobago Police Service after consultation with the Office of the DPP. I can tell you, ladies and gentlemen, again, as a matter in the public domain and as a matter of context, that Mr. Nelson, in his allegations, has pointed to criminal conduct by Mr. Ramlogan and Mr. Ramdeen. That criminal conduct is something which the DPP still has under his gaze, as he has publicly stated. I'd like to also let you know that in relation to the prosecutions, Mr. Nelson's particular conduct, Mr. Nelson was charged, and again, this is in the public domain. Mr. Nelson was charged with the following offences: conspiracy with Vincent Nelson that Anand Ramlogan misbehaved in public office of the Attorney General by accepting rewards from Vincent Nelson for Vincent Nelson being instructed as advocate in various matters in which the state was interested or in which the state was the client, contrary to common law. What does that mean? He accepted bribes. Secondly, conspiracy with Vincent Nelson to receive, conceal, and transfer criminal property, to wit, financial rewards given to Anand Ramlogan by Vincent Nelson, being instructed as advocate in various matters in which the state was interested or in which the state was the client, contrary to common law. And thirdly, conspiracy with Vincent Nelson to corruptly receive financial rewards from the said Vincent Nelson, being instructed as advocate in various matters in which the state was interested or in which the state was client, contrary to common law. Those are the charges, forgive me, against Attorney General Anand Ramlogan then and Gerald Ramdeen. And they were arrested on the 1st of May 2019. So I want to remind you in terms of context, notarized statement in 2017, state settled indemnity by Senior Counsel in 2017, disclosure to the DPP all throughout the period, investigation by the Trinidad and Tobago Police Service in 2018, plea discussion, plea agreement, entry of plea of guilt, sentencing before a judge. In the exercise of that, the only participants there were the office of the DPP and the police and the judge. In terms of the one side of the state, representatives from Mr. Nelson would have dealt with him. I'd like to say in relation to Mrs. Persad's allegations that there was something untoward about the state engaging in certain payments. I'd like to tell you that that matter is properly before the courts. It was the subject of written advice and other advice coming from eminent silk to the Office of the Attorney General, and there was full disclosure of all matters involving this matter. in 4 witness statements from me, and at every point along the way. And there are witnesses to all of these events. Mrs. Persad-Bissessar has referred to Mr. Roger Kewal Singh as a junior lawyer who received, according to her, millions of dollars in legal briefs. I'd like to remind the population that as Attorney General, I accounted to the nation and to the Parliament, and I confirm that the Office of the Attorney General, under my watch, paid Mr. Kewal Singh some $3.7 million. That is particularized in a statement laid before the Parliament. I can also tell you that Mr. Roger Kewal Singh received legal briefs from Mrs. Persad-Bissessar as the leader of the government, in her government handing him legal briefs at the Office of the Attorney General and in state enterprises. And I have confirmed that Mr. Kewal Singh received upward of $6 million in legal fees under the UNC watch. And if therefore Mr. Kewal Singh, who has been in practice for 29 years, called in 1993, if he was a junior attorney under my watch, surely he was therefore in kindergarten receiving multi-million-dollar briefs under Mrs. Persad-Bissessar. So I would really like you to put things into context. I don't need to speak for Mrs. Persad-Bissessar, but I would just tell her to be careful. She would also have to explain why Mr. Kewal Singh was counsel of choice in the Commission of Inquiry into the Clico matter appointed by her government. And Mr. Kewal Singh, in acting as an attorney under the Commission of Inquiry, everybody knows that commissions of inquiry fall under the office of the Prime Minister. So Mrs. Persad-Bissessar perhaps has forgotten the facts in relation to her own government's conduct. I'd like to say that in relation to the state's position, I think that context is very important. The state, in summary, was placed in a position with written evidence coming from a person who confessed to guilt. That written evidence was then interrogated by the Trinidad and Tobago Police Service. It was the subject of advice and action by the Director of Public Prosecution's Office. It was the subject of criminal charges leading to conviction and sentence. It was also the subject of further action in criminal charges being laid against Mr. Ramlogan and Mr. Ramdeen for their criminal conduct. Those matters have been discontinued by the Office of the Director of Public Prosecutions, but I want to remind that the DPP has specifically said, and I'm quoting from newspaper coverage of his positions, Gaspard was careful to note that his office may decide to reinstate the charges after Nelson's lawsuit is eventually determined. I will also remind, again from newspaper coverage, Mr. Gaspard pointed out that his office considered applying to have Nelson's witness statements tendered into evidence without him testifying. It is for those reasons that the matter is still alive before the DPP, in which I have no place or circumstance and will offer no advice, nor will the state intrude upon the DPP's exercise of his office. What I can say is that those are very material observations. I'll end before taking questions by saying Mrs. Persad-Bissessar is not a person without an interest in this matter. Mrs. Persad-Bissessar has declared that she is out to protect her members. She has declared that Mr. Ramlogan is her Attorney General, and in her mind is the only person should occupy that office. She has a vested interest in recovering his reputation. These are matters of criminal conduct reported and passed through a system which was very carefully managed by receiving expert advice from eminent senior counsel and Silk and external counsel as well. And therefore, this thing has been very carefully managed. The trap will be to step outside of what is in the public domain and get into the material of the matter. Anytime you start to talk about the matter, what you're going to do is you're going to fall into the trap of undue public influence or over public discussion or unfair trial issues, because there may be a prejudice to defendants in having to answer allegations where the population, particularly if you're going to have a jury, where the population has had too much discussion. The Privy Council has offered guidance in very careful circumstances in the Nankisoon Budram case that the state is bound to observe. I have confined myself solely and squarely to matters that are in the public domain and that have been published, particularly the charges and matters have all been published. I will not and cannot step into the particulars of what my witness statements say or don't say. I can tell you that before I left the Office of the Attorney General, that there are other matters that are being watched at internationally. There is a difficulty in something called tipping off, where you cannot say certain things. But when I held that office as central authority with an obligation for mutual legal assistance, all that I can tell you without tipping off anybody is that these matters are far from finished. I'm prohibited to say anything else. I'm certainly not the holder of the Office of the Attorney General. The Attorney General is a very capable person who will speak to matters if and when he can, and when prudent to do so, in the public interest. So in now opening the floor to questions, please, good members of the media, understand that I am constrained to make sure that we don't fall into the trap of giving Mrs. Persad-Bissessar that get-out-of-jail card that she so desperately wants. May I open the floor to your questions? Is it Andrea Murray?
Hi. Good morning.
Sorry, AZP News, Priya Bihari.
Yes, good morning, Minister. Minister, one of the issues that Mr. Persad-Bissessar raised was that how come Mr. Kewal Singh, who is representing Mr. Nelson in a claim against the state, how come he has been paid $6.6 million in legal fees by the state?
So, first of all, I just gave the caution that the particulars of a case and getting into the details of what is before the court is not something that can be done. I don't accept what Mrs. Persad-Bissessar says as truth or truth in context. And all that I can tell you is that the state had the benefit of senior counsel's advice in relation to all steps that were taken, and that has been disclosed in writing in witness statements before the court.
So has the state therefore paid Mr. Kewal Singh for representing Mr. Nelson in a civil case brought by him against the state?
So I'm trying to be very respectful, Priya, in telling you, as I've said before, that I'm prohibited from getting into the details, because once you ask one question, views are going to be cast in relation to it one way or the other. So regrettably, I'm not on cross-examination here this morning. What I am is explaining in context that the matters are before the court and that the DPP has indicated that he's still considering his steps in relation to reinstituting proceedings, and therefore I cannot overspeak the matter. What I can tell you is that every cent that has been paid to every lawyer in Trinidad and Tobago whilst I held the office has been laid in Parliament. It's a public document. Thank you.
Why did you go for indemnity agreement as opposed to a presidential pardon for Mr. Nelson?
Again, the law sets out how you apply for a presidential pardon. You must make an application. The state does not represent Mr. Nelson and cannot advise him. And all that I can repeat is that senior counsel's advice to the government, to the Office of the Attorney General, was that it was appropriate to take the steps in the very limited form of indemnity on civil matters that were offered. The indemnity offered by the state is very careful, settled by Mr. Mendez, and it does not speak for the Office of the DPP. It specifically acknowledges that the DPP and the police will be given all material, and that the DPP and the police will do as they see fit. That, again, is the subject of litigation, and the indemnity will have to be read in its full context, in its full meaning, for its true purpose. We have another question coming from Akash Samaru.
Hi, good morning, Minister.
Good morning.
Minister, did the Cabinet and by extension the Prime Minister approve this indemnity agreement?
The matter of the Office of the Attorney General's position is again the subject of disclosure into the court. Agreements that come under the Office of the Attorney General are under the Office of the Attorney General. The Constitution sets that out in Section 76 and 79, and the matters are carefully managed. I don't want to get into the details, again, respectfully, because the matters are under the watch of the DPP and also in the civil proceedings.
Okay, even though you said that the DPP may pick up the matter again in the future, you're saying that right now, even though there's no case specifically for this in front of the court, you can't say anything about it, whether or not the cabinet approved, the prime minister approved?
Well, I can't speak for the office of the DPP, as I said before. What I can tell you is that the DPP's comments quoted in the press are specifically, and I'll read it again, Gaspard was careful to note that his office may decide to reinstate the charges after Nelson's lawsuit is eventually determined. And I did say quite cryptically, without being able to go into the details, that there are other matters afoot, including international arrangements. So I can't speak to those factors yet.
Minister, in retrospect, right, do you feel as if you would have shot yourself in the foot by getting involved in the process with this indemnity agreement, in retrospect?
I don't feel one way or the other. I took the advice of eminent senior counsel in relation to the obligations of the Office of the Attorney General and followed that advice. The simple fact is, somebody came forward and said they stole money from the government, and they pointed fingers at two other people who stole money as well, according to the statement, Mr. Ramlogan and Mr. Ramdeen. Perhaps I should return the question by saying, what did you expect the state to do in the face of information? Remember, there's a distinction between the Office of the Attorney General on the civil side, and there's a distinction between the Office of the DPP, and there's been no cross-threading of those two issues. Should Mr. Ramlogan and Mr. Ramdeen just be given a bly and the state does nothing? That was the question. So the state took the responsible step of asking for advice, receiving that advice, and acting accordingly. Newsday, we have a question from you. Forgive me, I haven't received the name. I apologize.
That's all right. Good morning, Narissa Fraser.
Good morning,
I know you
Fraser.
mentioned some of the what you described as wild claims from the opposition leader, but I wanted your feedback on how it calls for your resignation, if possible.
I've often jokingly said that, and I mean this with the greatest of respect to a lady, I've often said that, Kamla, I don't want your crush. She's been calling for my resignation for 13 years straight. The day Mrs. Persad-Bissessar didn't call for my resignation, I think she'd be ill. So I know that her mission is to try and unseat her opponents. She's entitled to the freedom of expression and political expression, and I respect that freedom in this country. But Mrs. Persad-Bissessar has been calling for my head for 13 years straight. There's a follow-up question from Akash, please.
Yes, sir. Thank you. What would be your message to taxpayers of this country who are of the opinion that their money was wasted by all of this?
Okay, so we're dealing with litigation. And Akash, you've raised a very important point. This country has billions of dollars spent in tax-paying dollars pursuing litigation. Let's look at a matter which I recused myself from, but I'll just comment on from afar, from CLICO. Let's look at Life Sport. Let's look at Piarco Airport. It seems to be that there's always a choice, do something or do nothing. When you are an office holder, you are obliged to take advice. I certainly did that. I didn't advise myself on any of these matters. I consider Mr. Mendez to be one of the most eminent silk in the world, certainly in the Caribbean and definitely in Trinidad. And I consider Mr. Peterson, who has often represented the state on multiple matters, to be also eminent silk. And they are only two of the attorneys that we took advice from. What I can say is that the state has an obligation to act when you're faced with a written confession from somebody who has confessed to crimes and are pointing out to high office holders. You have a choice. You have to take action or you don't. That is costly. And in the case of Mr. Ramlogan and Mr. Ramdeen, they are well represented. I mean, Mrs. Elder is no cheap lawyer. Mrs. Elder was the beneficiary of millions and millions of dollars of state briefs for the excellent work that she conducted for the state at her part. She's a seasoned attorney at law. and they have taken every step in law that they're entitled to take. That is an expensive process. So the wheels of justice are frustrating, and yes, they are expensive, and yes, there's now a call for movement and quickness. Whilst I held the office of AG, I did my very best in my time at the wheel to improve the systems of justice by declogging systems and creating divisions of court and removing matters from the court. But the systems have to go to work. One thing a government can't do and will not do under Prime Minister Rowley is interfere with the office of the DPP. Mr. Gaspard is a very respected senior counsel who holds that office, and he has an unfettered discretion that we will not complain about. There are still significant matters that Mr. Ramlogan and Mr. Ramdeen have to answer to. The DPP has said that he is considering that position as time moves ahead, and I will not interfere with the Office of the Attorney General, nor with the Office of the DPP. Prior, I understand that you want to rejoin?
Yes, Minister. Have you spoken to the Prime Minister about this issue?
I have. Yes, I have, but not in any detail. The Prime Minister leaves matters of legal affairs to the Attorney General, and there's nothing to speak to the... Listen, these are not new allegations, you know. Let me remind you, Mrs. Persad-Bissessar's near entire budget contribution last year was on Faris. Her budget statements, Faris. Her platform statements, Faris. It's why I jokingly and most respectfully say, Mrs. Persad-Bissessar, I don't want your crush. And Mrs. Persad-Bissessar is not somebody who doesn't have a very vested interest in protecting Mr. Ramlogan. Who knows what secrets they keep between themselves? I don't know. Okay, it seems that we are out of questions.
Minister,
Prior?
Did you take the indemnity agreement before the cabinet?
You've come back to ask the same question I've answered already.
But
Akash? Yes, please, Akash.
Yeah, I was waiting to get unmuted there. You were speaking about claims from the opposition leader's press conference yesterday. She also did claim that Mr. Nelson is suing the state for $150 million. Is that true?
Mr. Nelson has brought a claim where effectively he is saying that he wants to ask the court to consider payment of sums, including sums which he would have earned had he not been put out of his chambers, etc., because he was convicted. Those are claims which the state stoutly resists, and the advice coming from senior counsel Mendez and also Mr. Peterson and their team of attorneys is that their case is bound to fail. I mean, let me remind you, Akash, there are cases all the time where people make wild claims in pursuit of matters. Mr. Nelson is represented currently by a gentleman named Shankar Bidesi. Shankar Bidesi, as you know, is somebody that has done a lot of work on behalf of the PP government under Mr. Ramlogan. I can't say anything more than putting forward a ridiculous claim is going to be doomed to fail. Now, I would love that matters could be argued in a panchayat system out in the public. But again, the state has to be very careful to marshal itself, to not overspeak beyond matters that are carefully dealt with. Because Mrs. Persad-Bissessar wants this country to fall into a trap of allowing Ramlogan and Ramdeen to get off scot-free. And that is called pre-trial publicity. There are civil proceedings, and the DPP has clearly said that he's reserving his right to come back to this matter, being careful from the newspaper advertisements, articles that I have read, to mark the spot on this. The Privy Council learning in the Nankisoon Budram case is very clear that you need to be sure that you don't overspeak the matter, because then the DPP may be forced to enter into the arena. Again, the office of the DPP is well represented by the DPP himself and Mr. Ed Jenkins, who is his Queen's Counsel, now King's Counsel, who has advised on this matter from day one and who received all of the statements coming from the office of the Attorney General with full disclosure, with hundreds of pages of documents. All of that is well received, and I will perhaps end by saying I have not seen a public criticism of me personally coming from the office of the DPP. I don't think there is any need for that. What I wanted to do was to tell people quite simply, watch Mrs. Persad-Bissessar Kokiai. She has a vested interest in this matter, and she's entitled to be an advocate for her people, but the state has an obligation to manage its affairs. The Office of the Attorney General has conduct of these matters on the civil side, and the Office of the DPP will consider whatever it wishes to consider without any interference from the Office of the Attorney General, and certainly not from me. My obligation was to give witness statements. I'll remind, I am also a witness in matters against Mr. Ramlogan for his witness tampering matter. And Mr. Ramlogan is still on another criminal charge. Mr. Ramlogan has just, as I read in the papers, started civil litigation in relation to those matters. So that's a matter for the courts at this point. Matters are properly in the courts. And I wish to thank ladies and gentlemen of the media for their questions and for allowing me this opportunity to put things into context. Thank you all so much and have a good day.
Emergencies can happen at a moment's notice. Mobility, hearing, learning, or seeing disabilities